Hi, everyone. Harry here to talk about Trump's continuing effort, even after the whole case is finished, dismissed by the U.S., and all the participants pardoned, to keep under wraps all the information in the Jack Smith special report. Okay, this is volume 2 of the report, which deals with Mar-a-Lago, which recall, but for the tender mercies of Judge Aileen Cannon's, to all appearances, seemed a very strong case. It wasn't simply that Trump had just ransacked and taken away all kinds of files, classified national defense information, and the like. It was also a whole series of obstructions, no way around it, where he holds the archives at bay and has a series of different excuses, and it goes on for months and months. Finally, the FBI has to serve a search warrant, which they do, and they find tons of additional stuff. This was after a subpoena clearly wasn't complied with. So a very strong open and shut case. Now, a case of, I would say, a crime by the President of the United States, but it hardly matters for these purposes. Case of serious conduct by the United States President that certainly bears on history and our national security and how things should be done even going forward. How do you handle situations like that? Well, first you give all the participants full due process. They, for a period of time, take priority because of our extreme commitment to individual due process and all the panoply of rights in the Constitution and related. But then you excavate the files. They then, any sort of personal vestigial interest of the people involved goes away because, and in particular here, given the way that the dismissals occurred, the statute of limitations, et cetera, there's no prospect that the case would somehow reemerge. And remember, by the way, we have Trump charged here, but also 2 co-conspirators, his kind of workers around Mar-a-Lago, Walt Nalta and Carlos de Oliveira, who almost certainly carried out orders to obstruct and moved boxes around and the like. So what you really have happening is Trump having fought and lied about the charges all the way around, and then having, by his good fortune of winning the presidency, the ability to just order by edict, nothing to do with the charges, that a case be dismissed. Now, the effort is really to completely excise it from the pages of history. Okay, and the actual context here is a effort by him and his co-defendants to resist the publication of the report. And it would seem that it would be a pretty hard motion to carry forward, but the good ship Aileen Cannon is piloting the issue, and who the hell knows what that could mean. She has yet to see an argument. Actually, 99% of the arguments she's seen, she's just green-lighted as far-fetched as they could be. So what we have here now is Trump coming in and saying, I want to participate in a motion, even though I'm no longer a party, and I want you to let me in as an amicus so I can argue that these materials should not be released. So it's clearly preparatory I think it's certain that she'll say, okay, you can participate. Let's hear your arguments. And then you'll have the spectacle or the extreme contrary to public interest argument by a president saying we must keep these under wraps. And taking a step back and thinking about this in tandem with the first prosecution, the January 6th prosecution itself, you have a sort of stunning effort to whitewash history that occurred in plain sight in front of everybody. So blatant misconduct at the election, and then after he finally left and took all these papers with him. And you have a complete fantasy version that they try to propagate. January 6th was 11, and they've said with increasing boldness of the January 6th offenders that they were terribly mistreated by the Biden administration, et cetera. This is the absolute revisionist history of the most, I would say, that it's certainly the largest operation in the history of the Department of Justice, and one of the most righteous as a necessary response to a breathtakingly serious crime against democracy. So same here. He here has advanced a total bogus version of the facts and the equities. And in particular, recall he continues to say that this search was absolutely improper, and they actually undertook it when he wasn't there. Total fact, they undertook it when he wasn't there because they didn't want to cause a scene. They went in a low-key way. They went in casual clothing. And what he's railing against is that they didn't give the heads up to the President of the United States that the search was about to happen. One never does that to the subject of a search. And in this case, would have been very borne out, because when he got the subpoena, his effort was to move things around and do everything he could to elude the legal operation of the subpoena. That's what he's done here. But so now you've got the 1-2 punch, as in the 1-6 case, the January 6th case, of first lying and trying to sort of seed the political culture with propaganda about the impropriety of the operation by Jack Smith, combined with keeping from public view important information about the that the special counsel developed that shows why Trump was charged with a crime. Even if your mindset is this was weaponization and it shouldn't have happened, it's essential, is it not, to have the actual facts and documents and actual progress of the investigation to evaluate that. If rather your vantage point is to understand whether a president of the United States committed serious crimes and very reckless ones that endangered national security, once again, you need the facts. In general, you need the facts. You need the facts after 9/11. You need the facts after the Kennedy assassination. And he's going to come in and try to proffer what for his administration is the paramount objective over any constitutional command, namely Trump's personal interest. But how that can hold water as against the great public interest is, I think, going to seem very far-fetched. However, of course, there's the whole card that he's playing, Judge Eileen Cannon. But, however, as to that, there is the court sitting above Eileen Cannon that we know has had a fair bit of frustration with Cannon and holds her at some arm's length and seemed ready to possibly pull the trigger on recusing her and the like. So, first summary here, and first point is Trump notwithstanding no basis for really withholding it now, and the great public interest in having it is going to go forward and say, bury this stuff. And then second, you may well see, as always, Cannon indulging him, and then we would see, will it play out in the 11th Circuit, and does he actually have a prospect of keeping this stuff from the eyes of the public for history, a sort of crime on crime, even with the obstructions, a crime on crime on crime, to keep buried any fact-based judgment and instead just rely on their completely dubious assertions of what happened here and who was right and who was wrong and whether the Biden administration weaponized justice and the like. So it's predictable, but very much contrary to democratic traditions, American traditions, and just the public interest in knowing what happened in this very serious episode. One of two, where he'll have tandem efforts in January 6th to change the subject, rewrite the text, and we've already seen it. So we're seeing, in real time in front of our eyes, an effort to just walk in, paint over the reality, and draw some fictitious picture. And it seems like the court should not let him get away with it, but starting with Eileen Cannon, it's something we got to watch carefully and continually insist on the public's right to know. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.